The judge told me when I went to court on Wednesday night.
What was on video?
They said they have a video of me and Cassius Bond in Tennessee.
Okay, I don't get access to any of that. Right here, all we were worried about is identity. Are you Naomi Burnett? And if you are, we establish the identity, that the charges are proper. If so, how do we go forward? A lot of times we let someone bond out if the person is not a danger, right? And we know that they're going to go back. But we don't know much about you, you know.
I have no criminal record. I have a degree, a bachelor's degree.
Hi, Ms. Burnett.
Hello.
Okay, so it looks like you're wanted somewhere. I don't know where.
One out of Rutherford County, Tennessee. Warrant was issued out on September 9, 2024. For 3 charges: theft of property $60,000 to $250,000, and identity theft of at least 10 counts, and a fraudulent use of a $60,000 to $250,000.
Hold on a second. Did you catch that? We're not talking about a small mistake here. These charges involve identity theft and up to $250,000 in fraud. In many states, that can mean serious felony time. But here's the twist. The woman in court says someone else used her identity. So the big question becomes, is she the mastermind or the victim of a massive identity theft scheme?
That she has no, and she did write a report on this, I believe, a few weeks before this charge came down on her.
So you're telling me that the felony capias and the $60,000 to $250,000 theft of property and the 10-count identity theft, the fraudulent use of a debit card of $60,000 to $250,000, all that was someone else?
Yes, Judge, that's what I'm being told. Ms. Burnett, go ahead.
Yes. So last year, I already filed a police report against Cassius Bond. He stole my social security number and he used it to open up an electricity bill in my name. And I also have other charges against him regarding burglary of an habitation. He broke into my house and stole my phone, and he stole money from me, and he also put his hands on me. So I'm guessing these charges are from him. I've never been to Tennessee before in my life.
How do we verify that?
Now, this is where things get complicated. The defendant claims she has never even been to Tennessee and says the real suspect is someone who allegedly stole her identity. If that's true, proving it could involve phone records, location data, surveillance footage, and financial transactions. But in a courtroom like this, the judge can't just take someone's word for it. They need hard evidence.
In Houston on those dates, whatever dates they're saying.
Okay, so I guess, I could have you get with the lawyer somehow, you guys. We've given you a lawyer. She's here to help you out in whatever manner that they can. I would suggest that you guys get together to figure out how. That's a lot of baggage.
I was working with the assistant district attorney. We were pressing charges on him. So I didn't know he was out of jail. He was supposed to be in jail still.
I guess I can have you guys talk about it. You've already waived, right?
Yes, Judge.
Do you know if Tennessee is going to come get her?
Here's the critical moment. Because the warrant is from another state, Tennessee has a limited time to pick her up. If they don't act within that window, she could be released from the local jail. But that doesn't mean the case disappears. The warrant would still follow her anywhere. So the real question is, will Tennessee come get her in time, or will she walk free for now?
Occurred from here, but the impact in Tennessee.
Here's the deal. We give the other jurisdiction 14 days to come get you. You've already been sitting in there and you waived already. So they only have 9 days to come and get you. If they don't come within that time, Harris County releases you. So, but I'll tell you, even if Harris County releases you, that warrant is always going to remain out there until you go back to Tennessee and try to take care of it one way or the other.
I don't mind going to Tennessee. I have transportation. I just don't want to remain in custody.
I know. No one does, right? But
and I was told that there was some type of video, so I don't see how it could be electronically done.
So it is worth noting that I never.
We don't know. We're speculating. We don't know.
No, the
how-
judge told me when I went to court on Wednesday night.
what was on video.
They said they have a video of me and Cassius Bond in Tennessee.
Just give me a second, Jake. Okay, I don't get access to any of that. Right here, all we were worried about is identity. Are you Naomi Burnett? And if you are, we establish the identity, that the charges are proper. If so, how do we go forward? A lot of times we let someone bond out if the person is not a danger, right? And we know that they're going to go back. But we don't know much about you, you know.
I have no criminal record. I have a degree, a bachelor's degree.
But
So if it's a matter of verifying the identity, if she's contesting identity, then she can withdraw the waiver and we can go for a governor's warrant. Or
I don't think she's contesting identity. She wants a bond, is what she
Well, like I
wants.
said, with the amount in the offense, with $250,000 on both theft of property and fraudulent use of credit card, and the fact that it's 10, which would be a third degree or second degree felony here, is that I'd be opposed with the sheer amount that is being alleged.
Yeah, one of the other things is that the higher level of charges, the more unlikely it is that we're going to give a bond, because the higher likelihood a person has of taking flight and not going back. So I don't know at this time whether I'm comfortable in setting you a bond. Okay. I don't know what connections you have here. I don't know what connections you have there. And the last thing I want to do is lose you, because that's a lot of stuff to answer to. And we want to make sure that, you know, whoever it is that has those charges is able to answer up to those charges. So
I also say that I already have a lawyer ready in Tennessee.
So what we can do here, what we can do is I can have you talk with Ms. Oko, figure out if there's some way that you can show that it's someone else, right? And if so, then we can talk more. Okay. But understand that I can't just take your word for it, you know?
Understand?
Okay. So
Even if I have police reports on him for already stealing my identity.
I'll let you talk with Ms. Oko, see what you can formulate, craft some kind of plan so that they're satisfied and I'm satisfied, and then we'll go from there. Okay. It's not a no. I mean, it's an uphill battle, but it's not a definite no at this point. Okay.
Understand?
Okay. Yeah. All right. Thanks. Thanks. And you know, just give me a heads up if you have anything, you know, different. Ms. Wickenhofer, in the flesh.
I know, right? We're famous, by the way. Over 30K people watched it. Anyways, it doesn't matter. I have to read off my phone, so I apologize, but
It's okay.
it says, Your Honor, I was convicted of driving while intoxicated in this court on October 14, 2019, under cause number 222. You already got it. I was sentenced to 4 days in jail, and I have completed that sentence, including paying all fines, costs, and restitutions. I am here today because I meet all the legal requirements under the Texas law for non-disclosure of this conviction. Specifically, number one, my conviction was for DWI with a blood alcohol level below 0.15, which actually was 0.11. I specifically remember. I was not placed on community supervision for this offense. This offense did not involve an accident with another person. I finished my sentence over 5 years ago. I have not been convicted or placed on deferred adjudication for any other crime except for minor traffic violations. This conviction from 6 years ago is still hurting my reputation and my ability to grow in my career. I deeply regret my actions and have learned from my mistakes. Since then, I have worked hard to turn my life around, and I am asking for a second chance. Granting this non-disclosure will allow me to fully move forward, both personally and professionally. It would help me reach my potential and improve my future. Thank you.
Absolutely. So I don't think I can. Show me where you think I can, you know, but non-disclosures are traditionally for people who take deferreds, complete the deferreds, and are eligible to have it sealed. Expunctions are for those that meet the requirements where if a case gets dismissed, they can have it expunged. Here, when you plead guilty, I don't think you're eligible for either. And the thing about it, I can't give you legal advice. I can't tell you how to look this, how to look that. But if you have a piece, or if you can show me the law that says